If your firm works with sub-advisors, here's a question worth asking right now. If one of them had a data incident today, would you hear about it within 72 hours? Under the SEC's amended Reg SP, that timing isn't just a best practice anymore. For many advisors, it's now an expectation. And the bigger surprise? Most sub-advisors are being treated as service providers for privacy and breach notification purposes, whether firms realize it or not. Let's talk about why. At its core, Reg SP is about protecting client non-public personal information, or NPI. The SEC's 2024 amendments put new emphasis on three things: third-party oversight, incident response, and timing. The SEC isn't focused on what you call the relationship: vendor, partner, sub-advisor. Those labels don't matter. What matters is one thing: does the third party have access to client information? If they can view it, store it, transmit it, or process it in connection with your services, the SEC expects vendor-level oversight. That's why most sub-advisors now fall inside the service provider framework. In a typical relationship, sub-advisors receive account-level data, portfolio holdings, performance information, or access to systems that contain client NPI. From a Reg SP perspective, that operational reality, not the professional role, determines your responsibility. And that leads to one of the most important changes under the amended rule. Advisors must now maintain policies and procedures designed to ensure that service providers notify them as soon as practicable, but no later than 72 hours after discovering unauthorized access to or use of client information. That 72-hour window matters, because once your firm is notified, you need time to investigate the incident and assess the risk of misuse. If misuse has occurred or is reasonably likely, notify affected individuals, no later than 30 days after that determination. If a service provider delays escalation, your firm may not be able to meet its own obligations. That's why SEC exam staff increasingly expects to see the 72-hour requirement clearly reflected in sub-advisory or vendor agreements, Reg SP policies, and incident response workflows. At this point, missing that expectation is often viewed as a program weakness, not just a contract issue. However, there is a narrow exception. If a sub-advisor contracts directly with the client and independently collects and maintains its own client information, without receiving NPI from the primary advisor, the sub-advisor may have its own standalone Reg SP responsibilities. But in practice, this exception is limited. If your firm shares onboarding data, portfolio information, reporting inputs, system access, or uses shared platforms, regulators are likely to view the sub-advisor as operating within your service provider framework, regardless of how the contract is structured or whether the sub-advisor has its own Reg SP obligations. And during exams, the focus is always the same. How does the data actually flow? Not what the relationship is called. So what should advisors be doing now? Start with visibility. Map how client information moves, internally and to third parties. If a sub-advisor has access to that information, treat the relationship as a service provider arrangement and apply appropriate oversight. Next, review your agreements. Make sure the 72-hour notification expectation is clearly documented. Then confirm alignment between your contract's Reg SP policies and incident response procedures. And if you believe a sub-advisor qualifies for the direct contract exception, document that analysis carefully and revisit it periodically. Operational changes over time can change the regulatory picture. Here's the bottom line. Under the amended Reg SP, sub-advisors are treated as service providers far more often than firms expect. If they have access to client information, the 72-hour notification expectation likely applies. Firms that rely on relationship labels instead of operational reality may face examination findings that regulators view as substantive compliance gaps. In today's environment, what regulators expect is clarity, clear data mapping, clear contractual expectations, and clear incident response readiness. If your firm is reviewing sub-advisory relationships or updating its Reg SP program, now is a good time to take a closer look before exam staff does. Need to stay current on regulatory updates and compliance trends? Subscribe and check the link in the description to sign up for our free regulatory alerts. At Legay Law, we make regulations make sense. Thanks for watching.